Please be seated. Good morning. We are here for oral argument in case number JV18 0321 in Re Jesus C. Counsel, each side has 20 minutes for your argument. The appellant may reserve a portion of that time for rebuttal. If you decide to reserve time, however, I would ask that you keep track of it yourself using the clock on the podium. These proceedings are being audio and video recorded, so we would be grateful if when you begin your argument, you would identify yourself and your client. We have read the briefs, discussed the case at conference, and are familiar with the arguments raised. And please keep that in mind when you're making your arguments. And with that, counsel, you may proceed.
Good morning. May it please the court, I'm Kevin Breger on behalf of Jesus C. As this court is well aware, it is our position that the trial court during the restitution hearing with regards to this matter did abuse its discretion when it awarded the victim an amount of $102,259.91. There are four significant reasons the trial court abused its discretion. And it's our position that each of these reasons in and of themselves are enough to raise to the point of being an abuse of discretion. But cumulatively, our position is that it takes the assessment to a whole different level, and the restitution award really should be vacated because of the abuse. The one significant reason the trial court abused its discretion was because there was an admission by the victim that it would cost $57,774.79 to repair the truck. Yet it was claiming a replacement value of $77,500. In and of itself, a $20,000 discrepancy with regards to what was being claimed versus what it could have cost to repair this.
Wasn't that subsequently clarified? Didn't the owner of the truck claim that it could not be repaired, that it was essentially totaled?
That was their claim, but in assessing whether a vehicle's been totaled or not, one's got to crunch the numbers, and one has to weigh up whether the value of the vehicle or the cost of repairs, exceeds the replacement value. On these numbers, since the cost of repair was...
You're saying that was the only evidence of the cost of repair? There wasn't any other evidence on the cost of repair? Or testimony that the truck could not be repaired, that there was simply a salvage value?
My understanding is that they were basing it on the demand that had been made by the owner of the truck itself, who had leased the truck to the victim. And the victim was basing, for the most part, their restitution claim of this young juvenile just based on the demand of the owner of the truck, the demand that they had received, and the demand was the basis for that number being hard and fast. The irony is, as the court's well aware, the victims were disputing that amount themselves, and they were litigating that amount.
But doesn't that put us in sort of a discretion land in terms of the courts faced with some conflicting evidence? But if the idea is to make the victim whole, it seems like we don't really want to force the victim to pursue litigation. If this is what's been demanded from the truck owner, is there a requirement that the victim initiate litigation against the truck owner to establish a lower damage amount?
There is not. But in this case, they did. The facts are that they were disputing that amount because they obviously believed, one would assume they obviously believed that amount was not a valid amount. And I'd ask this court to bear in mind, as the court is well aware, based on In Ryan A., State v. Ellis, In William L., that the court may not order restitution that would make the victim more than whole. So by all means, restitution is appropriate, but it is not appropriate to order restitution that would make the victim more than whole.
We're not necessarily talking about the victim, though. Here we're talking about the truck owner.
No, I'm talking about the victim who is claiming the restitution of the juvenile, because
it wasn't the evidence, though, before the court at the restitution hearing. This is how much the victim is being required to pay the trucking company.
yes, that was the evidence.
So the victim would not be getting any kind of a windfall. Maybe the trucking company is. Is that the?
No, the whole point is we really don't know, because that's the demand. But is that a valid demand? We don't know. It's being challenged. It's being litigated. And is that a valid number? We don't know. We're dealing with the unknowns, and we're asking this juvenile to pay a significant amount of money for just based on a demand that the victim received from the owner of the truck.
Mr. Breger, what do you believe is the appropriate amount should be awarded in this case in terms of restitution?
Well, taking everything into account, it's my belief that because so much was, because there was so much abuse on the record, I don't believe out of this restitution hearing there was a specific amount that the commissioner could have awarded. If there was additional evidence taken with regards to what was not disputed, what the victim agreed they did owe the owner of the truck versus what the owner of the truck was demanding of the victim, if there was some sort of specific amount that was put on the record that was undisputed, we might be in a different position today.
We don't have that number.
But we don't have that number. So the commissioner can't just suck a number out of her thumb, for lack of a better expression. So she does have to rely on the record, and it's significant that the law gives the commissioner very, very broad discretion. As this court is well aware, 8344A and, oh goodness me, I believe it's State v. Ellis, makes it clear that the trial court at a restitution hearing has very, very broad discretion in terms of what restitution to order. So,
but given that broad discretion, I mean, was there something that prevented questioning by your client's counsel to say we need additional information? I mean, at some point the court just has to make a decision based on the information that's before it, and it's hard to find an abuse of discretion if this is all the information that's available, and if there's evidence from which the court can infer this value, it's hard to find that that's an abuse of discretion.
In fairness to trial counsel for the juvenile, I don't think the onus was on him to prove the damages for the victim or to plug the gaps for the damages to the victim. His role was to challenge what was being claimed, and I think he did an admirable role of trying to do that. The state certainly could have stepped up and plugged those gaps. But the commissioner couldn't have just come up if there were gaps. It's hard for one to justify that there was not an abuse of discretion if there are glaring gaps, and one in all good faith cannot say the burden of preponderance of the evidence has been met, that restitution in the amount of X has been met.
Could your client have called a representative of the rental company? At the restitution hearing?
You mean of the victim you mean the victim
The company from which the victim rented the truck. My understanding, the victim didn't own the truck. It's the rental, whoever owned the truck. Was that company called to testify? Was a representative from that company requested?
Not to my knowledge, no.
Could I ask you? I hate to just completely free associate here, but on in terms of the residual value or the salvage value of the vehicle, what's your understanding of the record in terms of was there an agreed upon salvage value for the truck it's my understanding the trucking company asked for the replacement value of the truck, and presumably if it's the cost of a new truck, presumably you would subtract an agreed upon salvage value of the truck. Was there an agreed upon salvage value of the truck that they got to keep, that they didn't have to trade in to buy a new truck?
The record is silent with regards to that number. So no, to my knowledge, there isn't.
But is it clear that there was a salvage value?
I think common sense would dictate that there's always a salvage value of a destroyed vehicle in an accident.
So what's the amount that the court should attribute, though? Sometimes the salvage value could be presumably $500, $300. What would be our basis for saying there's an error or an abuse of discretion in not finding, in not subtracting out the salvage value?
I think the fact that we don't know that number, because the court is quite right. There could be a very broad range in terms of what those numbers could be. And judging by the replacement cost of this heavy equipment being at $77,500, one would assume that the salvage value is significantly more than $500. How much more, I don't know. And I think I'd be abusing my discretion if I tried to come up with a number.
But was that argued then? Counsel below argued that you should subtract out the salvage value of the vehicle?
Yes, he did. I believe trial counsel for the juvenile did argue that that is a factor that should be taken into account.
Did he suggest an amount?
He did not, to my knowledge, suggest a specific amount.
And is there some? Let's say down the road, there was an agreement between the victim and the trucking company. They reached an agreement that there was a $10,000 salvage value for this vehicle, so you only owe us $10,000 less than what we've asked for initially. Is there some mechanism for your client not having to pay as much? Is that something that can be raised in a PCR, or is there some? What would happen if that were to arise?
As the record stands, once the restitution order is final, it's final. And to my, given the state of the current record, if that were the case, then unless there was some sort of proviso, or unless it was anticipated.
Well, let me change my hypo, that if your client were to discover somehow, just doing research and having somebody ascertain that a truck in this condition, the salvage value would be at least $10,000. So regardless whether the victim worked something out with the trucking company, the company that owns the truck, would that be a basis for pursuing post-conviction relief, saying the failed to take into account, here's evidence of a salvage value, I should be credited for that amount?
Based on that hypothetical, I would submit no. It's not.
There would not be a remedy through a PCR?
No. I would suggest there isn't. If the record is final and that issue is not raised at the trial level.
That's the point of a PCR, though, to raise things that were not raised at trial. Maybe my counsel was ineffective for not doing this.
It could be, but that's hypothetical, and we're not dealing with that specific situation here.
So are you asking us to remand? Is that, are you saying there simply wasn't, it was an abuse of discretion, but just an abuse of discretion because there's not enough information, or that there's some number that we should come up with that's different?
My position is that the abuse is such that there is no specific number that I could ask this court in good faith to come up with to suggest to the trial court. So I would ask the court to vacate the restitution order, and as the court's well aware, that doesn't leave the victim without a remedy. They can pursue rights that they have as far as civil law is concerned.
Why would we not remand for if it's simply a failure to provide enough information on the part of the trial court?
Well, that is certainly, the court does have discretion to do that. I do submit that, but I would ask the court, because of the glaring gaps, not give the victim two bites at the cherry, so to speak.
Well, restitution, it's a constitutional right?
It is. But it's not absolute as far as criminal cases are concerned.
Right, but I think you're arguing the inverse, which is because there's not certainty as to a number, we should just throw it all out, rather than remand and identify a more precise number.
I do submit that this court does have discretion to do that, to remand and ask that the trial court to rehear the issue and clarify the number. But so just to summarize, the basis for the abuse is not that the $20,000 discrepancy. It's not just the fact that there was the salvage value that was not taken into account, the fact that the victim was going to keep the truck and be enriched as a result, but as has already been alluded to, the fact that they were going to or were disputing the amount claimed themselves. So it's our position that cumulatively all those things did rise to the level of being an abuse of discretion. And as has already been mentioned, the court has very broad discretion, and the trial court, based on the facts that were presented, could very well have denied the restitution request outright. They could have ordered an amount less than was requested. They could have ordered an amount that was significantly less than what was requested, or they could have concluded that no restitution was justified under the circumstances at all. And it's our position that since there was the abuse, that the restitution order should not stand. I would like to take issue with regards to, in State's answering brief, they make reference to the case of Re Julio L. And I would like to just distinguish that case. They rely on that case for the position that the court must view facts in the light most favorable to affirming the juvenile court's factual findings. The Julio L. case was not a case dealing with restitution. That was a case dealing with innocence or guilt.
Could you disagree with that general proposition? If there's evidence from which we can that would support the number the court reached, wouldn't we defer to that?
No.
Wouldn't we view it in the light most favorable to?
I think the analysis is different. I submit that the case authority dealing with restitution suggests that the abuse of discretion is the standard. But I don't.
But it is an abuse of discretion. Doesn't that contemplate we view the evidence in the light most favorable to sustaining the court's factual conclusions?
It's my submission that that's not the position. The State also makes reference to State v. Iniguez, 169 Arizona 533, appellate 1991, to suggest that the court should not set restitution in a criminal case based on anticipated civil damages. Now, it's curious that the State relies on this because, in a way, the underlying basis for our claim against the juvenile here was a civil demand, effectively, that was levied against him. And it's really that demand in and of itself which was relied upon for purposes of the Commissioner issuing the order. Irrespective of all the evidence that was presented, the demand in and of itself is really, at the end of the day, what held weight, and that's what was relied on in terms of how the number was, how she came up with a number for restitution. So it's our position that she shouldn't have done so, and that case supports that proposition. I would like to reserve the remainder of my time, if I may.
Thank you, counsel.
Thank you.
Good morning, Your Honors. May it please the Court, my name is Amanda Parker, appearing for the State of Arizona. This Court should affirm the restitution order as modified and suggested in the Court's brief, or excuse me, the State's brief, in the amount of $93,571.39.
Could you address the residual value or the salvage value of the vehicle? What's your understanding of the record in terms of whether there was a salvage value for that vehicle?
The parties apparently stipulated to Exhibit 5, which was the Houston Auto Appraiser exhibit, and that suggested an appraisal value of $12,000 plus or minus 25%. The trial court, the juvenile court, in her discretion, chose not to afford any type of appraisal value toward the restitution amount because Water Masters, our victim, did not possess the truck.
But why? But so there's an agreed an amount of $12,000.
No. I guess I should clarify that the exhibit itself was stipulated into evidence. There was never an agreement that there should be a salvage value.
But it seems to me that the court's ruling is just, I'm not going to award it because the victim's not possessing the truck. Is that fair?
That's fair, and I think even more so, I agree with opposing counsel that the basis of the restitution award was that demand letter from Neff.
But indulge my hypothetical here that everybody agrees, and there's been testimony that there is a $10,000 residual value for this. This is just a hypothetical.
Okay.
And it cost $100,000 to replace the truck, but the damaged one has a value of $10,000. Would we not say that it's an abuse of discretion to award more than $90,000, $100,000 minus the $10,000 agreed upon residual value of the damaged vehicle?
In your hypothetical, is the victim in possession of that salvaged truck?
Well, start with that. The victim has the salvage. I think you would agree that absolutely the victim has that. That's $10,000 available to the victim, so the victim hasn't been damaged $100,000.
The state would probably agree if the victim was in possession of the truck.
So why is it different if everybody agrees that and let's say the residual value is $80,000 on a $100,000, let's say $50,000, but the trucking company keeps the vehicle. But the trucking company and the victim have agreed that damaged vehicle could be sold, parted out, or whatever for $50,000. Are we not going to credit the defendant for that amount?
I think the difference is with the facts of this case, there is no agreement between Water Masters and Neff that there's a salvage value, and any way you look at it, Water Masters still owes that full value, the full demand that Neff is demanding. Neff is not crediting Water Masters for that $10,000 or $12,000 hypothetical salvage value.
But they stipulated to an exhibit, though it seems kind of close to an agreement that there is some sort of salvage value.
I don't know that the state would agree with that. I think that exhibit, it's Exhibit 5, was based on pictures from somebody in Texas. So I think even of itself, just the fact that you stipulate to it doesn't necessarily mean the trial court was...
So back to my hypo, where the trucking company keeps it, and there is a stipulation that there's a salvage value of $10,000. The victim hasn't kept it, and the trucking company is just being unreasonable to the victim and saying, we don't care, you owe us for the whole value of the truck. Would the defendant be obligated to pay the full amount, even though everybody has stipulated that there is some sort of residual value on that vehicle?
In that hypothetical, I think the trial court would have discretion to look at what the victim was actually out, what the victim's loss was, which in this case would not, and even in your hypothetical...
I'm agreeing the victim's out, but at some point, isn't it just kind of per se unreasonable to ignore the residual value of a vehicle?
I think if the goal of restitution is to make the victim whole, and crediting the victim a salvage value for an item that they don't possess would not make, in this case, Water Masters...
The goal of restitution is not to provide a windfall to the trucking company, surely.
So whether the juvenile in this case would have a recourse against the trucking company is... he might be able to do that, to say, I want the truck. I don't know. That's not the issue when we're looking at what would make Water Masters whole in this case.
So if there's we're talking about a chain, and there's a link between the defendant and here the rental company. The rental company can ask for whatever it wants, and because it's a pass-through, it's entitled to that, and restitution has to be paid by the defendant as to whatever might come into the imagination of the rental company.
No, and I think, focusing on the situation here, the demand from Neff was reasonable and was based on what the replacement value of a 2015 truck would have been. But say hypothetically, say Neff was demanding $300,000, I don't think the trial court or the state would be up here arguing that was a reasonable demand. But in this case, the facts of this case, that $93,571 was reasonable because it was based on a replacement value.
Replacement value, so that assumes you're getting a new one. So that assumes then that there's zero value in what you're keeping. That's where my disconnect comes in. It's hard to say, and I realize maybe there's only $300 dollars of residual value, maybe a tire or something, but assuming there's no disagreement that there is some value, it seems kind of per se unreasonable to charge the defendant the entire replacement cost.
And one thing I did want to clarify that I don't think the state explained very well in its brief was that replacement value in this case was for a same year model. They weren't replacement value. I think can also have a connotation that you're asking for a brand new one, and that's not what the situation was.
Right, but
here.
let's say you just get the exact same vehicle, the exact same number of miles. It was one that's in the exact same condition, but you then have that same vehicle and you have the other one sitting on your lot as well that has some value. Presumably you can sell the tires, you can part it out. So I take your position that it's not a brand new one, but you presumably got the exact, just what you lost. But then in addition, you now have this other one that's sitting there that seems to have some value, and we don't seem to be taking that into account.
But there's no value to our victim. Our victim has no way to attain any type of monetary reimbursement for a truck that they don't possess. And so there is no monetary value to our victim. There's no evidence that our victim is going to receive any type of windfall under these facts. So I understand the court's concern that there might be a potential value from the truck, the rental company, but that shouldn't be a detriment to our victim. Our victim should not have to potentially pursue.
But it's not but if we're just looking at a restitution hearing and we're just trying to decide if there's an abuse of discretion, I guess your position would be, I hate to put words in your mouth, but assuming the court says, well, you should take into account a $10,000 replacement value, we would then put the victim in the position of having to litigate against the trucking company. Is that your...
Correct, and I think just the broader picture is that the juvenile court has discretion to look at the unique facts. These facts are really unique, but to look at the facts of the case and set restitution in a manner that would make the victim whole. And anything less than what was ordered, that $93,000, would not make Watermasters whole in this case.
Well, I mean, the distinguishing factor here is the pass-through, right?
The fact that the property was not owned by the victim?
Right, that the windfall,
assuming there is one,
right, would be for the rental company to receive, because in this instance the victim is just paying a bill.
correct.
Okay, so could the victim call the rental company in the restitution hearing and elicit testimony as to value?
They could have.
Well, and let's say the trucking company said, we want a brand new vehicle. So we want a $100,000 vehicle, not one that has the exact same miles, same condition. I mean, does the victim says, this is what they're asking for. I'm just a pass-through. You got to pay the $100,000. I mean, we wouldn't be able to say that's an abuse of discretion. They've asked for more than the value of the vehicle that was damaged.
The court might be able to say it was an abuse of discretion to order, or for the court to use for the NEF demand letter to be the $100,000 versus the 93 or the.
So then, how does that change if we could say that's an abuse of discretion, and if there is an agreed upon, and maybe you're saying there's not an agreed upon residual value, but if there were, wouldn't we be able to say there's similarly an abuse of discretion? We're not going to give you a brand new vehicle to replace the one that's 8 years old.
I don't think the court needs to decide that, because the facts of this case, the demand from NEF to Watermasters was reasonable. It wasn't.
Is it reasonable to ignore the residual value is the question.
I think if the court is to subtract any type of amount for the value of the truck, it's going to leave Watermasters, the victim, less than whole. And the juvenile court's intent here clearly was to make the victim whole. And but for the juvenile's delinquent conduct, Watermasters would not owe that.
Or what if we were to remand it for a finding on whether there's on the residual value of the truck?
I think the court had what it needed to potentially consider it, and it didn't matter because Watermasters didn't possess the truck. So there's really nothing that a remand or further evidence on that residual value would add to this issue, because Watermasters doesn't have the truck. They're at the mercy of NEF.
So if that's the case, if that's all that matters, then again, the rental company can ask for the sky, and it's not in the possession of the victim, and so it's not at issue, and the defendant will be on the hook at the end of the day? I mean, isn't it a fact, the question of loss? I mean, if you had here the rental company coming back and say, you know what, it was actually a Rolls Royce that they wrecked, and we want $1.5 million. Under that rule that you just articulated, the criminal defendant will be on the hook because they don't possess, the victim doesn't possess the Rolls Royce.
I think we take our victim as we find them, and it might be somewhat analogous to the situation where a vehicle is damaged, where the defendant causes a collision that damages a vehicle that maybe the victim owes more money on than it's worth. It's viable for for restitution to be set at the amount of what that victim owes, not what the car is worth. And so I guess in that situation, you're taking the victim as you find them.
But you do agree that if the trucking company demands the cost for a brand new vehicle rather than a 7-year-old vehicle, you would agree that that's an abuse of discretion?
I think no, I don't know that I would say that's an abuse of discretion, but you take the victim as you find them, and so.
Okay, but that's how we're finding the victim. A 7-year-old truck was damaged. The trucking company wants to buy a brand new one to replace it, and is demanding that the victim pay for that.
And I think if the victim owes that amount, the juvenile court has discretion to order that amount. And whether the juvenile has an independent recourse civilly against the third party is a separate question. But when we're talking about restitution and what would make the victim whole, there really is no other option here other than to afford Watermasters the amount that Neff was demanding, which is reasonable. I think that's the key here, that Neff's demand to Watermasters is reasonable, and they're not asking for a Rolls Royce, they're not asking for a new vehicle. So I understand the concerns that might be present. Maybe
unless there is a salvage value of $20,000. It's not reasonable if there is a salvage value.
Well, there is evidence from the other exhibit that was admitted, which was Exhibit 8, that nobody would fix it. So that I guess you're putting, Neff would have to piece out.
That's what I'm saying. A salvage value is if you could just take it to a junkyard and they will give you $10,000 for it today. It would seem to me it would be an abuse of discretion not to credit. If the victim has it in their possession and if they're paying for the whole thing, it seems to me they're entitled to it. So I'm struggling.
If the victim has it in their possession.
Yeah, but so even if they don't, it seems like it's just per se unreasonable for the trucking company to ask them to pay to replace it and not give them the truck.
But in your Honor's hypothetical, if Neff never lowers its demand to Watermasters, then and if the restitution amount is lowered by that hypothetical $10,000 amount, then our victim is the one who's out that $10,000, and that's a detriment to the victim, and it's not the victim's fault that the juvenile decided to go break into the lot and drive a front loader into the dump truck. So I don't think there's any other way, given the unique facts of this case, to make the victim whole. But whether the juvenile could potentially litigate that issue against Neff is a separate issue. But there's no evidence that there is going to be any other type of windfall to the victim.
Sorry to interrupt, but
Sure.
if let's say the court had said, I realize Neff is charging you $100,000, but I find that there's a $10,000 residual value. Would that not operate to prevent Neff from going against the victim and saying you got to pay more than $90,000? I'm just making up numbers here. But if the court had made the finding, I realize Neff is asking for $100,000, but you had a $10,000 residual value, so I'm going to say the harm is only $90,000. Would that be an abuse of discretion? It would arguably leave the victim having to litigate against Neff, but would you say it's an abuse of discretion if the court had said there's a $10,000 residual value? Wouldn't that prevent Neff from coming in and saying, you owe me more than $90,000?
I think that there's still the option that that Watermasters could be out the $10,000, because in your Honor's hypothetical, you're expecting that Neff will drop its demand to match the ultimate restitution order. If
the court finds as a makes factual findings and saying there is a residual value of $10,000 in that vehicle, wouldn't that, and Neff had a chance to argue that no, there's no residual value, wouldn't that preclude them from going after the victim for more than $90,000?
I don't know that Neff would have the opportunity to come in on its own and interject what it thought the contract dispute outcome should be between Neff and Watermasters. But I think the unique situation here is that juvenile appeals with the disposition and the restitution are packaged together. And I agree with counsel that I do think the restitution order is final, that there is no option for prior to the juvenile's 18th birthday, for example, for the court to modify this. If there is any type of successful litigation between Watermasters and Neff, that would have to be litigated outside of this criminal case.
What's the incentive for the two of them to litigate anything?
For Watermasters and Neff?
Right. If there's a...
Because
well, I guess
the likelihood of the juvenile, I mean,
actually paying,
if he,
so,
yeah, exactly. I mean, Watermasters has incentive to litigate that against Neff because they owe the $100,000 or the...
Assume they do litigate it. Is there some vehicle for them reducing the amount of...
I don't think there is. I think juvenile cases are unique, and I couldn't find a statute or case that would allow the juvenile court to modify the restitution order. It's final for purposes of appeal, and I think juvenile cases are unique and distinct from adult cases in that regard. But I think the juvenile could potentially sue Neff or some type of assuming he pays, right? That if he pays this full amount, then he could litigate that against Watermasters for some type of civil unjust enrichment, perhaps, or something like that. We don't know what the nature of dispute is between Watermasters and Neff. We don't know that there will potentially be any type of different demand from Neff to Watermasters. And
Parker, I'll ask you the same question I asked Mr. Breger. What's the number you think we should land on?
The number that we should land on is the $93,500 total restitution?
Yes.
$93,571.39. That includes the 2015 Ford truck, taxes, 3 months of rental income, and then the transportation costs back and forth. The state, as we agreed in the brief, some of those rental debts should...
Exceeded about $8,600.
Right, that's correct. That's correct. That should not have been added in there twice. If I could just have a minute to make sure there's nothing else. I wanted to make clear that the state's not stipulating that there is even a salvaged value. So even though that exhibit was admitted, the court did not find that there was a salvage value. But even if there was, the court was not obligated to assess that as a credit to the victim.
It's just stipulated to the admission of the
Exactly.
exhibit, not the amount.
Exactly.
The correct amount.
And if you look at that exhibit, there would be discretion as a factual matter for the court to say that this isn't sufficient for me to determine that there is a $12,000 salvage value. But the exhibit itself was stipulated. The court had discretion not to consider that. If the court doesn't have any other questions, the state asks your honors to affirm the restitution award in the amount of $93,571.39.
Thank you, counsel.
I'd like to just briefly address the one point that the state's attorney repeatedly indicated for the record, that the amount of $93,571.39 was reasonable. Because of the gaps during the restitution hearing, and because of the very fact that the victim themselves was disputing or litigating this demand and this amount, it's not fair to conclude for this court or the trial court that that amount is reasonable. It may be a reasonable amount, but we don't have enough information, and we have enough...
There's going to be litigation for another 5 years. Does the court just hold off and not issue a restitution award? Doesn't the court have some discretion to say, this is, based on what's in front of me, this is what I'm going to order?
The court absolutely has discretion, and it's our position that the court should say, on these facts, since we can't come up with a number certain, we're not going to issue restitution order against the juvenile at this point. And the victim can pursue their remedy in the realm of civil litigation, which the law allows for. So it's our position that we shouldn't just come up with a number just because we want to make the victims happy, so to speak. There is also reference to one of the cases, in the interests of time, in Re Elton D. The state seems to rely on that to suggest that victims have a right to a speedy restitution resolution. On a closer analysis of that case, the court there speaks to speedy trial rights for the juvenile and speedy remedy rights for the victim. A closer analysis of that case suggests, in my opinion, that speedy trial rights for the juvenile take precedence. So we would ask the court to give the juvenile the benefit. Thank you.
Thank you, counsel. Thank you both for your arguments, and we'll have a decision in the ordinary course.